Equal justice under law. These are proud words that form a proud motto. They express the ultimate purpose of jurisprudence, and that nation is indeed proclaimed their realization. These are the words inscribed upon the modern Grecian temple housing the Supreme Court of the United States. With the executive and the legislative branches, the Supreme Court and the judiciary system form the three cornerstones upon which our constitutional republic is founded. Alexander Hamilton had said of the Supreme Court, quote, "The judiciary, from the nature of its functions, will always be the least dangerous to the political right of the Constitution," end quote. For nearly a century and a half from the date of its founding, the Supreme Court had not only been the least dangerous branch of our government, but there had been times when it seemed to stand as the last bastion protecting the Constitution from those who would have it destroyed. The Supreme Court justices, being men of character and wisdom, reached decisions based not on their own dictates, but in conformity with the Constitution, leaving any desirable changes to be made by the people through the amendment procedure. And down through the years, the United States Supreme Court grew in public esteem, not only for the soundness and wisdom of its decisions, but also for the integrity of the men who had rendered them. There was John Jay, the court's first Chief Justice, who had joined with James Madison and Alexander Hamilton in the writing of the Federalist Papers. And John Marshall, who had first asserted the right of the Supreme Court to pass upon the constitutionality of acts of Congress. And William Howard Taft, who had also been President of the United States. And Charles Evans Hughes, who narrowly missed becoming the President. And many other distinguished jurists, men of high purpose and integrity whose service brought honor to the court. But in recent years, many Americans have come to realize that the Supreme Court, to which we had become accustomed to look for justice in the highest sense, had begun to pursue a different path, exercising powers not granted to it in the Constitution, the making rather than the adjudicating of laws. The greatest prison break of all time. That is how an article in This Week magazine described the results of a recent decision of the United States Supreme Court. In the case of Gideon versus Wainwright, the Supreme Court ruled that the accused criminal was not only entitled to have legal counsel, but that the tax-paying citizen must pay for free legal counsel for indigent defendants. This decision has resulted in a Pandora's box being opened up, and prisons everywhere are having to release imprisoned thieves, rapists, and murderers. More than 1,000 convicted criminals have been set free in the state of Florida alone. The Supreme Court has replaced the steel prison doors with turnstiles. An article in this issue of Time magazine admitted, quote, "In many cases where the courts have granted a new trial, it is virtually impossible for the prosecutor to rebuild the case. Records and evidence are gone. Witnesses have disappeared," end quote. Danny Escobedo was convicted of rape and murder, but today he walks the streets. For the Supreme Court reversed his conviction on the grounds that he had been questioned by the police before being permitted to see an attorney. And in the Miranda case, the Supreme Court went even further, ruling that the police cannot question a suspect if he indicates in any way that he does not want to be questioned. The effects of these recent new laws created by the Supreme Court have been rapid and far-reaching. No one could fail to notice the unusual caution with which the police of Chicago have been forced to approach the case of the vicious killer of 8 young student nurses, fearing that the slightest error on their part could result in his being set free, even after his capture and conviction. Many lawyers, concerned over recent Supreme Court decisions, have expressed their belief that the suspected killer could not receive a fair trial because of the publicity given the case during the search for him. The fact is not taken into account that without the publication of his description, particularly that of certain tattoo markings, the suspected murderer might have escaped capture. With violence erupting in the streets of America, from border to border and coast to coast, and criminals becoming even more brazen in their disregard for the laws that protect the law-abiding citizen and his family, many Americans ask, what sort of men are these Supreme Court justices, whose decisions have resulted in legal chaos and more concern for the slayer than the slain? The senior member of today's court is Justice Hugo L. Black, appointed to the bench by President Franklin Delano Roosevelt in 1937. With the exception of 18 months as a police court judge, Supreme Court Justice Black was entirely lacking in judicial experience. Justice Black's principal distinction was that of being a rabid New Deal rubber stamp senator. And Americans everywhere were shocked when Justice Black admitted that he had been a member of the Ku Klux Klan. President Roosevelt's other remaining appointee is Justice William O. Douglas, who at the time of his appointment had absolutely no judicial experience. Even while devoting time and energy to compiling an amazing record on the matrimonial merry-go-round, Justice Douglas has found time to be an almost constant critic of capitalism and the American free enterprise system. Justice Tom C. Clark was appointed to the High Court by President Harry Truman. Justice Clark is another who, prior to his appointment to the United States Supreme Court, had never served a day on any court bench. During his 8 years in office, President Eisenhower had the opportunity of naming 5 members to the Supreme Court. He named as Associate Justices John M. Harlan, William J. Brennan, Jr., Potter Stewart, Charles E. Whitaker, now retired, and as Chief Justice of the Supreme Court, Earl Warren. Prior to his appointment in 1953 as head of the highest court in the land, Earl Warren had no judicial experience whatsoever. In 3 terms as governor of California, Earl Warren had endorsed almost every extension of federal government power into the affairs of the state of California, had vigorously opposed the requirement of loyalty oaths for teachers in taxpayer-supported schools, and, when asked about the legislative investigation of communist activities in California, Governor Warren responded with the evasive and time-worn cliché that although he was, quote, in favor of the principle, end quote, he was opposed to some of the tactics used. Justice John Harlan, until his nomination to the Supreme Court, was a member of the Atlantic Union Committee, a group favoring the surrender of American independence. The oath he would be required to take as a new justice conflicted with the aims of this group. When this was pointed out during the Senate hearings on his appointment, Justice Harlan withdrew from the Atlantic Union Committee. Justice William Brennan, appointed in 1957 by President Eisenhower, seems a strange choice for a Republican president to have made, since he was well known as a highly vocal left-wing Democrat. Justice Potter Stewart, prior to his appointment to the United States Supreme Court, served for 4 years on the United States Court of Appeals. As one of the few members of the High Court with any prior judicial experience, he finds himself in strange company. Of the 2 justices appointed by President Kennedy, Justice Byron White is the one remaining. With no prior judicial experience, his principal qualification seems to be that of having been a football player. A place on the court was created for Abe Fortas by his old friend, President Johnson, who persuaded the other President Kennedy appointee, Arthur Goldberg, to become our ambassador to the United Nations organization. Justice Fortas can scarcely be said to have ennobled the court by his presence, his qualifications being merely long and faithful service to Lyndon Baines Johnson. It was Abe Fortas who prevailed upon Justice Black to certify the Democratic senatorial nomination of Lyndon Baines Johnson in the Ballot Box 13 scandal of the 1948 Texas primary elections. This certification halted an investigation into the very peculiar circumstances of the voting in the town of Alice, Texas, where ballots were cast by more than 100 dead people. And Mr. Johnson was presented with a landslide victory by only 87 votes out of the nearly 1 million cast, enabling him to embark upon his climb to the presidency. Abe Fortas has performed other valuable services for Mr. Johnson and Mr. Johnson's friends, having acted as counsel for the ex-Senate page boy and self-made millionaire Bobby Baker, and prevailing upon the newspapers just prior to the 1964 presidential election to hold back the story of the Walter Jenkins scandal while methods for softening the shock to the nation were being sought. This is our Supreme Court today. Byron Raymond White, William Joseph Brennan, Jr., Potter Stewart, Abe Fortas, Tom Campbell Clark, Hugo Lafayette Black, Earl Warren, William Orville Douglas, and John Marshall Harlan. These are the men who have been selected to tell us just what the Constitution says. Where earlier courts consisted of men having a profound respect for the Constitution, today's justices and their recent predecessors seemingly respect nothing but their own philosophies. The law of the land is no longer what the Constitution says it is, but what Earl Warren and his associates would like it to be. This is not merely the opinion of observers unschooled in the law. An assemblage of some of the highest legal authorities in the land at a conference of the chief justices from each of the individual states expressed their concern over recent Supreme Court decisions and in an official statement urged that, quote, the Supreme Court of the United States, in exercising the great powers confided to it, exercise one of the greatest of all judicial powers, the power of judicial self-restraint. By recognizing and giving effect to the difference between that which, on the one hand, the Constitution may prescribe or permit, and that which, on the other, a majority of the Supreme Court may deem desirable or undesirable. End quote. Many Americans, including FBI Director J. Edgar Hoover, are expressing concern over a trend in the Warren Court's decisions in cases involving subversive conspirators who are working tirelessly to destroy the American system of government and deprive each American of his individual freedoms. In the case of Jenks versus the United States, Clinton Jenks, a Union official, was convicted of perjury for having falsely filed an affidavit stating that he was not a communist. Completely disregarding the fact that he was guilty, his conviction for perjury was reversed by the Warren Court on the grounds that he had not been shown the FBI files containing the evidence against him. The Federal Subversive Activities Control Board had ruled that the Communist Party of the USA was an agent of the international communist conspiracy and must register as a subversive organization. But, based on the Warren Court decision in the Jenks case, a United States Court of Appeals reversed this ruling on the grounds that the Communist Party had not been shown the FBI files. Of course, if the Communists are permitted to examine FBI files, the FBI undercover agents would be exposed and the effectiveness of the FBI's anti-communist work will be lost. This is but one example of the Warren Court logic. Another example is the case of Pennsylvania versus Nelson. Steve Nelson, well-known communist author, is an admitted communist and one of the leaders in that international conspiracy. Nelson was convicted under the anti-sedition laws of Pennsylvania for plotting the violent overthrow of the government. He was sentenced to 20 years in prison, and this conviction was upheld by the Pennsylvania State Supreme Court. But the Warren Court, in a decision written by Chief Justice Warren himself, destroyed the anti-sedition laws of 42 states, setting Nelson free in the process to continue his unholy work. What were the grounds upon which this remarkable decision was based? The Warren Court declared that Congress, by passage of federal laws against the violent overthrow of our government, particularly the Smith Act, had taken from the states their right to prosecute subversives under their own anti-sedition laws. This is strange logic, since the Smith Act specifically states that it does not preempt the right of the states to prosecute subversives under their own laws. And then, the Warren Court proceeded to virtually void the Smith Act as well. This was accomplished in the case of Yates versus the United States, in which the Warren Court reversed the convictions under the Smith Act of 14 West Coast communists. This decision caused Dorothy Healey, communist spokesman for the West Coast, to rejoice, quote, "This is the greatest victory the Communist Party ever had," end quote. A pre-Warren court of 1951 ruled that the communist conspiracy was a, quote, "clear and present danger," end quote, to the security of the nation. But in Yates versus the United States, the Warren Court made a complete about-face and ruled that clear and present danger was too vague a term, and that no danger could be shown until a concrete act of violence had been committed. All citizens realize that it is not only the right, but the duty of a government to protect itself and its citizens from acts of destruction. Our nation's history reveals numerous instances when the local, state, or federal government has done so. No rational person would say that a government, becoming aware of a plot to blow up its capital, should sit idly by while the plotters went about their planning, procuring explosives, planting them in the building, and lighting the fuse before it could take steps to halt the proceedings. Presumably, the Warren Court would say that every action preceding the actual explosion is an abstraction, and any action taken to interfere would be a violation of the plotters' so-called civil rights. The only trouble with that is a nation can lose more capitals that way. Should the Nelson and Yates cases appear to be isolated exercises in sheer insanity, let us consider Slowchower versus the Board of Higher Education. According to a New York City law in effect since 1938, any teacher in its taxpayers-supported school system refusing to answer questions regarding communist affiliations when called before an official investigative committee was to be dismissed automatically. Harry Slowchower, a teacher at Brooklyn College, a school supported by the taxpayers of the city of New York, hid behind the Fifth Amendment when questioned about his communist affiliations and associations. The New York City Board of Higher Education fired him. This decision was upheld in the lower courts, but then the Warren Court took over, deciding that the taxpayers, through their elected officials, had no right to protect their children from indoctrination by questionable teachers. Slowchower was ordered reinstated to his job and given $40,000 in back pay. The final nail in the coffin of parental dissent from communist indoctrination was hammered home by the Warren Court in Sweezy versus New Hampshire. Paul M. Sweezy, by his own words in numerous articles such as this one, acknowledges his opposition to the American concept of private property. Sweezy is also a professor at the University of New Hampshire and was accused of preaching the virtues of communism to his students. When questioned on 2 occasions by the New Hampshire Attorney General, he refused to testify concerning his questionable affiliations and associations. The New Hampshire Supreme Court held Sweezy in contempt. But Earl Warren and Company came through as expected, reversing the decision. Chief Justice Warren, with Justices Black, Douglas, and Harlan concurring, thought that New Hampshire had not gone about it in quite the right way. And Justice Felix Frankfurter, now retired, in a separate but concurring opinion, handed down a brand new law, which said that state officials may not inquire into the affiliations or ideologies of professors in taxpayer-supported schools. Rosalie Gordon, in her book 9 Men Against America, commented on this incredible decision. Quote, "You build buildings for them to teach in. You hire them, but don't you dare ask if they are good Americans." End quote. She could very well have added that you as a parent and taxpayer have no rights in such matters since you only furnish the children and the money. It is interesting to note that in the 1962 school prayer decision, the Warren Court decided it could be harmful for children to hear a simple, non-sectarian prayer. But in the case of Sweezy, the court evidently felt that they wouldn't be harmed by having to listen to Marxist preaching. John Stuart Service was a highly placed official in the China section of the State Department, one of that elite group which did so much to deliver China to the communists. This congressional report disclosed some very interesting activities of Mr. Service, such as supplying classified government documents to the editor of the magazine Amerasia, which had been officially cited by the United States government as, quote, communist-controlled, end quote. The FBI discovered these extracurricular activities of Mr. Service, and he admitted passing highly classified government documents to Philip Jaffe, the communist editor of Amerasia magazine. Instead of being prosecuted under the law for his actions, our State Department merely dismissed him. For such gentle treatment by our State Department, one would have thought that Service would have been eternally grateful. Instead, he brought suit against the United States government to regain his old job. And the United States Supreme Court thoroughly supported him, ordering him reinstated to his job and paid his back salary for the time he had been unemployed. Communist subversives have been using the courts for many years to carry on their never-ending battle to destroy the American way of life. We have reviewed but a few of the cases in which the communist-supported position is obvious and easily identifiable. Senator James Eastland recently had published in the U.S. Congressional Record a comprehensive list of such cases and how each Supreme Court justice ruled in these cases. A brief glance at this scoreboard should be shocking to every American. Justice Earl Warren, in rendering decisions on 65 cases involving communist-supported positions, rendered 62 decisions supporting the communist position. Hugo Black, in 102 cases, 102 supporting votes. William O. Douglas, in 100 cases, 97 supporting votes. William Brennan, in 51 cases, 49 supporting votes. Interestingly enough, John Harlan, in 65 cases, only 30 supporting votes. Potter Stewart, in 20 cases, only 6 supporting votes. Tom Clark, in 82 cases, only 21. Justices White and Fortas, being the most recent additions to the court, were not included in the chart. The Founding Fathers, when they pledged their lives, their fortunes, and their sacred honor in the struggle to win our nation's independence, could not have foreseen that time when men lacking in foresight and principles would be named to the highest court in the land. Even now, realizing that it has happened, it is difficult to believe. But Thomas Jefferson did catch a glimpse of this terrible possibility, and when writing his memoirs in 1821, he cautioned, quote, "It has long been my opinion that the germ of dissolution of our federal government is in the constitution of the federal judiciary, an irresponsible body, advancing its noiseless step like a thief over the field of jurisdiction. Until all shall be usurped from the states, and the government of all be consolidated into one. To this I am opposed, because when all government shall be drawn to Washington as the center of all power, it will render powerless the checks provided of one government on another, and will become as venal and oppressive as the government from which we separated." End quote. Fearing the encroachment of power by one branch of government over another, the drafters of our Constitution made every effort to secure a system of checks and balances in our national government. Article 1, Section 1 of our Constitution states, quote, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives." End quote. This is clear and concise language. It should be clear even to the Supreme Court justices themselves that they are not entrusted with the power to make laws, that only Congress can enact the laws of the land. Article 3, Section 2, Paragraph 2 goes even further. Quote, "The Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as the Congress shall make." End quote. With this system of checks and balances, the American people, through their elected representatives, have the power to protect their freedoms from what Thomas Jefferson said could become an irresponsible body. One course of action could be for Congress to limit the court's jurisdiction. The American people are tolerant and law-abiding and have great respect for those who serve in our judiciary system. But it might be well for the justices to remember that the Supreme Court, no matter how well-intentioned, is still bound by that system of checks and balances. Daniel Webster sounded these words of warning to those who would be tempted to entrust too much power to the hands of those who govern. Quote, "Good intentions will always be pleaded for every assumption of power. It is hardly too strong to say that the Constitution was made to guard the people against the dangers of good intentions. There are men in all ages who mean to govern well, but they mean to govern." End quote. We cannot, of course, know the inner thoughts of the members of the Supreme Court. We do not know if they are men of good intentions, but the facts clearly show that they do mean to govern. Those who are concerned over the facts presented in this film can do something. First, gain additional knowledge about the Supreme Court's actions from the large number of documented books available, and then to increase the effectiveness of your efforts, join with others who share your concern in their efforts to build the understanding necessary to preserve this constitutional republic. The question that must be answered is, will the freedom-loving people of America continue to sit idly and complacently by, ignoring the continual erosion of their personal freedom and the destruction of this nation? It is up to you. What will you do?